Hello and welcome to Tuesday's episode of the Nieves Law Firm. We're going to do Tip Tuesday. I'm a little delayed in starting this video, and that's because I'm just getting back from court where we had yet another victory where our client petitioned for early termination of probation, and it was granted. We petitioned to have his felony reduced to a misdemeanor, and that was granted. And we petitioned to have his entire case dismissed, and that was granted. So another success for the client and the Nieves Law Firm. But that's not the Tip Tuesday for today. Truth be told, Tip Tuesday is if you've got an issue, you should hire us. But what I wanted to talk about today was Miranda, because everybody's always heard on, crime shows, Law and Order and Special Victims Unit, you've got the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't hire one will be appointed to you. And those are called your Miranda warnings. And the most important thing to know about that is you do have the right to remain silent. You have a right against self-incrimination under the Fifth Amendment. So a question that comes up often is, you're being investigated for a DUI and then you're taken into custody and they never read you your Miranda rights. People are always like, can I get the case thrown out because they didn't give me Miranda? And the issue there is that they're not required to. The officers are not required to give you Miranda warnings unless they are going to question you, like interrogate you in custody. So, and it doesn't mean that you have to be behind bars for a custodial interrogation. It just means that you have to be in a custodial state where you're not free to leave or they're not in the course of performing more of an investigation. So usually the pre-field sobriety test questions, the reason you can refuse them is because they're not based on like your identity, but they can be asked without giving Miranda because you're not yet under arrest. They're still trying to figure out what's going on, or at least that's the theory behind it. So an officer does not have to give you your Miranda warnings unless you are actually being interrogated and you're in custody. And so if for some reason you have been arrested and taken into custody and then they want to question you about the crime and look into it further, see whether or not you've actually have any helpful information or anything that could be used against you, because one thing to keep in mind is that you cannot talk yourself out of jail. You'll only talk yourself further into it, and that's why you should preserve your right against self-incrimination and your right to remain silent. But if they want to question you once they have you in custody, those warnings do need to be given. If they don't, then there will possibly be a Miranda violation. So yep, it is Tip Tuesday. Hi. So that is our tip for today, just knowing the difference between when Miranda is proper and required and when it's not. And then, in the event that you are taken into custody for a DUI, just breaking the bad news to you now that no, the failure to give you Miranda doesn't automatically get your case dismissed. It really depends on the circumstances. Were you in custody and were you interrogated? If you have any more questions about that, I'm happy to answer them. Or if you've got a situation that you need some assistance with, you can give us a call. We'll be happy to assist you. Bye. Have a great one.